Well, good afternoon. My name is, can you hear me? Okay. Yeah. My name is John Levy. It's my distinct privilege to serve as the 10th chair of the board of the Legal Services Corporation. And on behalf of our outstanding LSC board, I welcome you to this forum on increasing access to justice. And as many of you know, it takes place on the very first day of LSC's 50th year. And how special for us to be here in New York City on this day. After all, New York City was home to a number of individuals, and I should say is still home, who helped to create, preserve, and lead the Legal Services Corporation. Of course, I refer to the legendary Sargent Shriver and two of LSC's past presidents, the remarkable Alex Forger, who is now in his own second century, and Helene Barnett, who chairs New York State's Access to Justice Commission. They're not here with us today because of concerns about COVID still, but they promise they will be here when we return next year for a special 50th anniversary commemoration event. And of course, New York City is home to the largest program in LSC's national network, with extraordinary leadership, which we heard from today, and also across the river in neighboring New Jersey. I want to thank the Ford Foundation for providing this terrific facility and all the technical support for producing, recording this program. The Ford Foundation has been an important supporter of LSC initiatives for which we do not receive congressional appropriations. It helped to fund our civil court data project last year to build a more comprehensive court records database and made possible our significant statewide legal aid website evaluation effort, helping our grantees all across the country improve their websites in 2015 and 16. And we'll be privileged to be welcomed today by our host, Tanya Koch, the Ford Foundation's Director of Gender, Racial, and Ethnic Justice. A number of distinguished speakers will follow Tanya to the podium, including Chief Judge Rowan Wilson of the New York Court of Appeals, Michael Schmittberger, who chairs the executive committee of my firm, Sidley Austin, the American Bar's President, Deborah Enix Ross, and Doug Eakley, the founder and co-director of the Center for Corporate Law and Governance at Rutgers Law School and a former LSC board chair. And on that point, Doug and Frank, would you please stand for just a second? You have three chairs in succession here. Frank Strickland from Atlanta, our immediate predecessor. This represents more than half of the history of LSC. Today's program also features two panels. In the first, legal aid and judicial leaders from three cities that have made it a right for tenants to have a lawyer when facing eviction will share lessons learned from the process, and LSC's president, Ron Flagg, will moderate. And in the second, our LSC board member and former ABA president, Robert Gray, will lead a discussion of the importance of access to justice for American business with three leaders of nation's prominent companies. As I said, we were gathered here on a significant day because the LSC Act was actually signed on July 25, 1974. And you know, last night I mentioned this, it's kind of emotional for me because by the time the first LSC board was appointed. My father was the United States Attorney General, and I'm told he played a significant hand in the selection of the first LSC board. Well, we intend to mark this landmark anniversary year as more than an occasion for commemoration, but also a call for renewal and determination in pursuing equal access to justice for all Americans. The many projects, events, and initiatives we've planned across the country for this year and next will shed new light on a wide variety of access to justice issues and address a persistent, pressing problem that plagues LSC and has since its founding, the civil justice gap. LSC's 2022 Justice Gap Report demonstrated just how wide that gap still is, revealing, sadly, that low-income Americans do not receive any or enough legal help for 92% of their substantial civil legal problems. Chronic underfunding of LSC and its grantees is helping to fuel this crisis in civil legal aid, and as grateful as we are that the omnibus spending bill passed recently by Congress increased LSC's funding to $560 million, which represented a 14.5% hike, much more is needed to close the justice gap after years of wholly inadequate funding. In fiscal year 1994, 30 years ago, Congress appropriated $400 million for LSC. By fiscal year 2023, to only increase us modestly to $560, well, that is not remotely enough to keep up with inflation, much less the increased demand and need for services resulting from recessions, population growth, and a pandemic that have occurred in the last 3 decades. And the prospects for increased funding right now look rather bleak. 2 weeks ago, the Senate Appropriations Committee released a fiscal year 2024 budget that maintains LSC funding at $560 million, but the next day, the House Appropriations Subcommittee released a budget that cuts us by $71 million back down to $489 million. Now, those proposed cuts, if the House were to prevail there, would be devastating. LSC estimates that as a result, over 272,000 fewer low-income people and families across the nation would receive legal assistance on life-impacting matters such as evictions, veterans' benefits, domestic violence, and LSC grantees already having to turn away so many just because of a lack of resources would be forced to turn away yet another 118,000 children, 25,000 survivors of domestic violence, and almost 5,000 veterans. Cutting or even plateauing LSC funding at this time is just unacceptable. It further threatens our country's confidence in the fair accessibility of our justice system, and as the Justice Gap study further showed, only 28% of low-income Americans, and incidentally, that's just about a fifth of our population, believe that people like them are treated fairly in the U.S. civil justice system. How much lower as a country can we afford to let that number fall? In March, LSC requested from Congress an appropriation of $1.5 billion for its 2024 budget. This request accounts for the serious lack of adequate resources to address this justice gap. And we strongly encourage members of Congress not just to consider it, but to adopt it as the budget for LSC as negotiations move forward, because every penny and more of that budget request is needed to fully realize the foundational American promise of equal access to justice, enshrined in the preamble of our Constitution, engraved on the facade of the Supreme Court, invoked by Americans of all stripes and color when they recite the Pledge of Allegiance. From former Chief Judge of New York's Court of Appeals, Jonathan Lippman, who's done so much for LSC in the civil legal aid community, powerfully observed in a law review article that Americans must ensure, quote, that the scales of Lady Justice are exquisitely balanced, regardless of one's wealth or station in life. The pursuit of justice for all should and must be our mission, and the judiciary, the profession, and the academy are essential players in this endeavor. Well, another essential player in the pursuit of justice for all is legal assistance and legal aid providers, as Justice Antonin Scalia so powerfully explained during his stirring remarks at LSC's 40th anniversary, and I quote him, "Those of you who have children know that they will accept begrudgingly, but without principled protest, the most arbitrary rules, be in by 11, no TV on even-numbered days, no eating potato chips, but deny equal application of any rule, forbid one child to do what another is permitted to do, and you'll hear howls of protest, howls of injustice." Equal treatment is the element of justice most fundamental, most ingrained in human nature. And today's law-ridden society, denial of access to professional legal assistance is denial of equal justice. As LSC enters its 50th year today, and as our country approaches its 250th birthday, just a few years from now, we call on all of us, you, me, all of the Congress people across the country, state houses, governors, senators, presidents, to ensure that the essential element of equal justice, legal assistance, is afforded to all who need it, so that we can keep faith in our time with our country's promise of equal justice for all. Thank you very much. It's now my great pleasure to introduce our host, our next speaker, Tanya Koch. Tanya is the Ford Foundation's Director of Gender, Racial, and Ethnic Justice Team. Previously, she served as a distinguished lecturer at the John Jay College of Criminal Justice, the City University of New York, was a program director on criminal justice for the Open Society Institute, and a program manager for the U.S. Human Rights Fund. Tanya, sincerest thanks to you, your colleagues. They've been working behind the scenes. They've been working their magic, but making it possible for this event to take place in our meetings here at the Ford Foundation. Thank you so much.
Thank you, John, for that warm welcome, and greetings to our friends at the Legal Services Corporation and your many allies. We are so delighted to have you with us today. And I want to extend special greetings to Councilwoman Brewer, who I believe is in the room, and Chief Judge Wilson of the New York Court of Appeals, and Judge Eckholt from Missouri. Welcome, welcome to the Ford Foundation. And on behalf of our president, Darren Walker, who could not be here today, I just want to express the warmest welcome to our friends from LSC. LSC has long been a grantee of the Ford Foundation. It was an anchor grantee of our Access to Civil Justice portfolio for decades. And although in recent years, much of our justice-related funding in our core program has focused on the crisis of mass incarceration in the criminal legal system, we continue to try to be as helpful as we can to our friends at LSC through project support, as John noted. And of course, LSC recognizing that the civil courts and access to justice in the civil legal system is a fundamental obligation of a just society. And of course, LSC as an essential organization helping our country to make the promise of equal justice a reality. As John noted, I am a lawyer myself, and I have a soft spot for legal services, having spent my first summer as an intern in law school with the Legal Aid Society of Harlem in the 1990s. And in that office, we have representatives from Harlem's in the house. Okay. And my summer there, it was the summer of 1991. I remember it well because it was also the summer that Thurgood Marshall died, and that fell like a bomb on the staff that summer. But I fell under the tutelage of an exceptionally tough and talented lawyer there, a Black woman who had grown up in the shadows of the George Washington Bridge, and she really did her lawyering with the lived experience of someone who understood both the racism and the other barriers facing low-income people as they struggled to negotiate public benefits, to obtain repairs on their apartments, to forestall an eviction, or to resolve a divorce or a child custody battle. And even though she knew from experience that appointments in the city welfare offices never proceeded on time, she was insistent that I show up not only on time, but early to my appointments, to greet my clients, to sit with them as they waited, to see a public benefits officer. And I think she did that because she wanted me to understand, as a relatively privileged person, what it was like for mothers with small children or young unemployed men, what it was like for them to navigate the poor people's bureaucracy of New York City, right? And she wanted me to do my lawyering from a humble place. And I will tell you, I changed a fair number of diapers that summer, alongside more traditional legal advocacy, but I really consider that time as one of the most important aspects of my training. And I did later go on to become a public defender, and that has really stayed with me. I also remember in that office being wowed, truly awed by a woman named Leslie Decora Holmes, who some of you might remember. She was then a supervising attorney in the Harlem office. Like me, she had been a Ruth Tilden Scholar at NYU Law School, and she had, I remember, just the most commanding knowledge of housing law. It was thrilling to watch her in court. But she as a supervisor, she was manning the phones on intake day with an equally commanding knowledge of Spanish. She spoke Spanish, fluent Spanishly. And I remember shadowing her while she conducted the most empathetic yet probing client interview I've ever witnessed. It was really a virtual masterclass in building trust with a client. And that, too, has stayed with me, along with my other supervisors' admonitions to Tanya, stop making assumptions. Every time I would start a debrief with her and say something, well, I assume the client, she's like, no, Tanya, there are no assumptions. There are only facts. You go back and you get the story from your client. So anyway, all a good reminder that at the heart of the corporation are incredibly talented, dedicated lawyers, paralegals, support people who are at the heart of ensuring that our civil legal system is doing the work that it needs to do on behalf of poor and vulnerable people. And so we were so thrilled to welcome you here today to Ford, and we wish you a productive conversation for the remainder of the day. Thank you.
Hello, my name is Father Pius Petrick. I'm the Vice Chairman of the Board of Directors of the Legal Services Corporation. And it is my distinct pleasure of introducing our next speaker, Chief Judge Rowan Wilson. It's wonderful for us to be back in New York. We've had a long relationship, particularly here in New York, with the judiciary. Judge Jonathan Lippman, as John Levy has said, was a great, great friend to ours. For many years, I had the pleasure of co-chairing our disaster recovery task force with him. Judge Wilson, I just want to let you know, we will allow you to do Court of Appeals work from time to time, but we do expect you to do just as much as Jonathan Lippman did for the Legal Services Corporation. Judge Wilson joined the bench in New York here in 2017 as an associate, and earlier this year, Judge Hochul nominated him to serve as Chief Judge of the Court of Appeals for the state of New York. And for those of you who are not from New York, the Court of Appeals is in fact the highest court, not the secondary one, as I sometimes get confused about. He was previously a partner with the firm of Cravath, Swaine & Moore. In private practice, Judge Wilson was involved in several charitable organizations, their boards of directors, and not-for-profit organizations, and handled a number of pro bono matters. So thank you very much for coming down from Albany to be with us today, and we look forward to hearing from you, Judge Wilson.
Well, not to disappoint anyone, but my chambers are really here. I go to Albany for arguments, but I can walk back to my chambers in 5 minutes. It's a pleasure to be here, and thank you to the board and to Chairman Levy for inviting me to come. Chief Judge Lippman, whose name you've heard a couple times, created New York's Permanent Commission on Access to Justice, and over time secured $100 million annually, now it's up to $112 million, to begin to address the dire need for representation in civil matters for those unable to afford a lawyer. Along with the Commission's longtime chair, Helene Barnett, I've attended several meetings of the national conferences on access to justice, and I can report that no other state comes close to New York's commitment. I can also report that New York's commitment falls far short of any conceivable measure of need. The Commission has been working for the last 2 years to develop a rigorous and conservative estimate of what it would take to provide civil representation to persons at or below twice the U.S. poverty line for the most pressing types of matters, including eviction, consumer debt, child support, and disability benefits. The Commission estimates that nearly an additional $1 billion annually would be required in New York. Myriad studies document the magnitude of the need, the tremendous deficit faced by unrepresented litigants, and the drastic societal consequences that result when the better outcomes available to represented litigants are unavailable to unrepresented litigants. I'm not going to restate any of that information today, and I think you all know it. Instead, I propose we think about this question by returning to first principles. Why is there a right to counsel in criminal cases? A simple answer, I suppose, is it's in the Constitution, but that answer isn't very informative. A few basic points help to frame the fuller answer. First, the principal objection to including the guarantees of rights in the Constitution when it was sent out for ratification was that those rights were among the rights that could not be taken away by a government, and listing some of them might imply that others could be curtailed by a government. Second, the Bill of Rights, including the Sixth Amendment, all represent restrictions on the power of the federal government. The Bill of Rights, including the Sixth Amendment, did not constrain the state governments until much later via the doctrine of selective incorporation based on the Due Process Clause of the 14th Amendment, a point which I'll return to in a bit. At the time of the adoption of the Constitution or the Bill of Rights, state law guaranteeing rights flowed from two sources: the common law that states had incorporated from England and state constitutions. We then need to travel back in time to the time of Henry VII, the year 1495 to be precise, when Parliament adopted an act to admit such persons as are poor to sue in forma pauperis. The Act provided that in civil actions in the King's courts, the chancellors and justices, and I quote, shall appoint attorneys for poor persons and all other officers requisite and necessary to be had for the speed of the said suits, and to be had and made, which shall do their duties without any rewards for the council's help and business in the same. In explaining the Act's genesis, Parliament cited King Henry's concern that, and I quote again, poor subjects be not of ability nor power to sue according to the laws of the land for the redress of injuries and the wrongs to them daily done, and observed that the king intends indifferent justice to be had and ministered according to his common laws to all his true subjects, to poor as well as rich. In addition to Parliament's legislative history, which suggests that the Act was a restatement of the common law, other facts point to that same conclusion. Nearly 200 years before the Act, the King's justices in Eyre appointed counsel to poor litigants in civil matters, and English ecclesiastical courts did the same for paupers. 2 decades before the Act, the King's Bench compelled the English elite attorneys to represent poor persons. In the 1800s, English judges and historians opined that the Act was confirmatory of the common law. Finally, although the Act applied only to courts of law, the equity courts in England subsequently adopted the same right. It might surprise you to hear that under English common law, indigent civil litigants were entitled to counsel, but criminal litigants were not. As the U.S. Supreme Court explained in Powell v. Alabama, originally, in England, a person charged with treason or felony was denied the aid of counsel except in respect of legal questions which the accused himself might suggest. At the same time, parties in civil cases and persons accused of misdemeanors were entitled to the full assistance of counsel. After the Revolution of 1688, the rule was abolished as to treason, but was otherwise steadily adhered to until 1836, when by an act of Parliament, the full right was granted in respect of felonies generally. What seems to us odd that under the common law, indigent civil litigants had the right to counsel, whereas indigent criminal defendants did not, can be understood in the following way. Civil disputes were not disputes against the crown, and the king had an interest in the perception that his courts were open to all and unbiased. Crimes were offenses against the crown. Why should the common law aid those who offended the king? It is against that common law background that we should return to the Sixth Amendment and the fear that enumerating some constitutional restrictions on governmental power might imply that the government was free to deny other rights. Because only English statutory law, not common law, provided a right to counsel, and then only in felonies, and because the federal government, though sovereign, was not intended to have the powers or structure of monarchy, it was important to constitutionalize the right to counsel in criminal cases as against the federal government. Thus, my answer to the question as why we have a right to counsel in criminal cases is because, unlike in civil cases, the common law right to free representation was lacking. Turning back to the 14th Amendment, it is only by operation of its due process clause that the constitutional right in criminal cases applies to states. It is long settled that the Sixth Amendment applies to any case in which imprisonment is a possibility, even misdemeanors. Due process, of course, means what is necessary to the fundamental fairness of a system, in this case, the court system. And under the doctrine of selective incorporation, the 14th Amendment incorporates against states only those rights deemed fundamental, which the right to counsel is. That brings me then to the following questions. Imagine you are very poor. Which would be more fundamental to you? Having counsel in a case in which you might be sentenced to 30 days in jail, or one in which you might lose your home? How about one in which you might lose your children, your job, your disability benefits, your child support? I can't answer for any of you or anyone else, but I would rather spend 30 days in jail than lose any of those other things. And at least in theory, I might need a lawyer more in a civil matter, because in a criminal matter, the government has a higher burden of proof. I can put my point simply. There are some civil matters that have a more catastrophic real-world consequence than some criminal matters. The dichotomy between the constitutional right to counsel in criminal cases and the absence of a similar constitutional right in civil matters should not be taken to arise from some determination that indigent criminal defendants should have lawyers and indigent civil litigants should not, but rather from the need in the past to constitutionalize a criminal right to counsel to address a deficiency in the common law. The principal difference, then, about to whom to provide counsel is not a clear dichotomy between criminal and civil matters, but rather a judgment about the severity of the potential consequences for the individual and for society. Even in criminal cases, we limit the resources available to indigent defendants based, ultimately, on a judgment about how much resource society is willing to devote to that representation when considered along with all other expenditures the government makes. When we consider the proper extent to the right to counsel in civil cases, the analytical framework should be no different than in criminal cases. Are the potential consequences to the individual and society sufficiently grave to warrant the provision of counsel? And what magnitude of resources do we wish to provide to support a right to counsel? Presently, we are not doing nearly enough. Thank you.
Chief Judge Wilson, I thank you. Let's give Chief Judge another round of applause for those. You know, I've been doing access to justice work for, the better part of my career, Judge, and I've never heard an analysis as insightful as yours, and I can't think of a better segue to our next panel, and I'm going to ask our Right to Counsel panel to come up, because our next panel is going to talk about right to counsel in just one important area of civil law, that is eviction cases. So on to that. All right. Well, again, thank you all for being here. I'm Ron Flagg, President of Legal Services Corporation. And as I said a moment ago, our panel today is going to talk about the one area of civil law where legislatures, state legislatures, city councils, county supervisors have deemed it important enough to provide right to counsel, and that is in eviction cases. And let me provide a little context for that. Let's go back to the good old days prior to the pandemic. In the good old days prior to the pandemic, the annual eviction rate in the United States, I believe in 2018, was 3.6 million evictions. And of course, if we're talking about 3.6 million evictions, we're talking many more millions of seniors and children all wrapped up in those evictions. And when we talk about evictions, we're not just talking about people losing their homes. We're talking about people losing access to their jobs, to their children's schools, to health care. We're talking about family arrangements disrupted. So losing your home, as Chief Judge Wilson suggested, is far worse than even a short stay in jail, and can really be a lifetime sentence of misery for those involved. So that's the good old days prior to the pandemic. Then we go to the pandemic, and in 2020, at the outset of the pandemic, up to 30% of America's renters face the risk of losing their homes because of the spike in unemployment that occurred at the outset of the pandemic. And fortunately, the government responded, both federal, here in New York State, local governments, but across the country. And we had moratoria, and we had emergency rental assistance, federally funded, $46 billion. And so fortunately, the tsunami of evictions that we feared did not occur, at least not fully, in the immediate wake of the pandemic. But of course, those things have all gone away. The eviction moratoria are largely expired, and the emergency rental assistance is now dwindled in most places to nothing. And so we really face another crisis, continuation of the eviction crisis that we've faced now for many years. And up to 20% of America's renters face potential eviction. Given the gravity of evictions, given the volume of evictions, a number of jurisdictions, I believe it's 5 states and 18 local governments, have enacted right to counsel laws across the country. And we have the opportunity today to talk about how those arose and how they're going in 3 places: New York City, Newark, and Kansas City. And we've got 3 different perspectives from each of those communities to be shared with us. And now it's my privilege to introduce my colleagues from next to me to farthest away, Kabira Myers, who is the coordinator for the Office of Tenant Legal Services in the city of Newark. And from Kansas City, we have, or the Kansas City metropolitan area, we have the Honorable Dennis Eckhold, who is on the 6th District Court there. And next to Judge Eckhold, we have Ron Rasmussen, who's the Executive Director of Legal Services of New York City, which is the single largest legal aid program in America. And I'm just honored to have all 3 of them here with me today. So I'd like to start by asking sort of how your right to counsel laws originated. 2 of them originated prior to the pandemic, one after the pandemic rolled out, and sort of what the who was responsible for advocating for them and what they entail. So Ron, New York City's right to counsel law, I think, goes back to 2017, and as such, you're our senior panel member.
I'm happy to start. Is this on?
Yep.
Yes. Okay, great. So New York City has a long, strong history of tenant activism, of tenant organizing, and of legal services, lawyers and legal services programs working very closely with those tenant activists and organizers. And for the 50 years that Housing Court has existed in New York City, we have been pushing very hard to expose all the bad things that happen there and to fight against the bad things that happen there. And we know that when tenants are threatened with eviction, first, they're threatened. And they're threatened with the loss of their homes and the fear about what that means for their families and their children. Then they go to Housing Court, and they stand in long lines because they're in a poor person's court that's badly funded and that doesn't have enough staff to support the kind of processing of cases that occurs in federal court. Anyone who's ever been there did not stand in a long line and did not see long lines of people, mostly black and brown, on the streets outside of the courts, waiting for an hour or more to get into the court and to be filled with fear while they waited that their cases were going to be called, they were going to be defaulted, and they were going to lose their apartments without ever having made it into the building. So for the entire history of the Housing Court, we have been pushing hard to fight against the way Housing Court is processed, but also to ask and to demand that a right to a lawyer be appointed for tenants who are in Housing Court. Because we know during the entire history of Housing Court, 90% of landlords have lawyers, 10% of tenants at most have lawyers. And so fast forward up to 2014, the Right to Counsel Coalition formed, which is a coalition of tenant-based community organizations and tenant organizers and legal services programs. A law was drafted then and pushed for the next 3 years very hard by the Right to Counsel Coalition. And in 2017, in August of 2017, the first right to counsel law in the country was adopted by a progressive city council and mayor. And we've been working since that time to implement that law. That law provides for a right to a lawyer for tenants who are being sued in housing court who have incomes under 200% of the federal poverty level, which is about $60,000 for a family of 4. And any tenant who comes in is entitled to that lawyer, but unfortunately, and we'll talk about this in a little bit, there aren't enough lawyers to go around just yet.
You mentioned the 90% representation rate for landlords and 10% for tenants, and that holds true across the country. That's generally the breakdown we see across the country, where you have historically, 90% or more landlords represented and 10% or fewer tenants, and it makes a difference. Again, if you look across the data nationwide, basically, if you don't have a lawyer in eviction court, you lose your home. Maybe you even default, or often you default. If you have a lawyer, on average, you win. You stay in your home. You are able to stay longer than you otherwise would have. So it's really a dispositive factor as to whether or not you have counsel. Kabir, at Newark was just a year later in terms of right to counsel. Can you tell us how it arose and sort of what the outlines of the program are?
Absolutely. And good afternoon, everyone. And first of all, I would like to thank Legal Services Corporation for this opportunity. This is tremendous. I'm extremely honored to be amongst everyone here. I'd also like to thank the Ford Foundation for allowing us to use this absolutely beautiful facility and for its support for pro bono attorneys and legislation. So if I could just give some background about the City of Newark's quote-unquote right to counsel legislation and the office that I run, around 2018, Newark Mayor Ras Baraka introduced a multi-layered blueprint for equitable growth and housing stability in the City of Newark. One layer of that blueprint was the introduction of right to counsel legislation and an associated office to implement and uphold that legislation. So thankfully, in 2018, the Newark City Council passed that right to counsel legislation. Shortly thereafter, I was offered to run the office called the Office of Tenant Legal Services. And I also want to thank the City of New York for being the harbinger, right? You guys are amazing. When our legislation was introduced, Mayor de Blasio came down to the City of Newark and joined us in announcing to the public that we have this right to counsel legislation that we would like to get passed. And I think that it's because of your support that we have the right to counsel legislation that we have now in the City of Newark. So similar to the eligibility criteria of New York, the City of Newark's Office of Tenant Legal Services has eligibility criteria. We only provide defense attorneys to Newark tenants whose household income does not surpass 200% of the current federal poverty level. And we do make exception for seniors, people who are over the age of 60 and infirm. And so again, this is, this office that I run is a product of a progressive mayor, Mayor Baraka, who had the vision and the foresight to introduce this type of right to counsel legislation, because the City of Newark, if I could just say really quickly, and I could go on, Mr. Flagg, so please cut me off. I'm very, very passionate about right to counsel in the evictions landscape. The City
Why?
of Newark, housing is everything. If you don't have a home, you pretty much don't have much of anything else. And mental health and housing are symbiotic, right? So you can't upkeep your mental health if you don't have a home. If you don't have a home, then whatever mental health disabilities you might have is exacerbated. And so housing is everything. It really is. I could keep going about that. But the City of Newark is a municipality of tenants, right? So the City of Newark has about 300,000 residents, about 80% of which are tenants, the majority of whom are rent burdened. You know, and I think that everyone in this audience knows what that means, right? Like you're spending more than 30% of your household income on rent, which means that the majority of Newark residents are susceptible to the threat of eviction. They're facing the threat of eviction. So that was part of the reason why Mayor Baraka had the foresight to, to make this happen, this right to counsel happen in the city of Newark. Thank you so much.
Thanks a lot. So let's move forward 4 years. We're now in the pandemic, and these right to counsel laws, which in a couple of instances arose here on the East Coast and the New York metropolitan area, are now sprouting up in other places, Cleveland, Kansas City. Judge Eckold, how did the program arise in Kansas City, and sort of what are the outlines of it?
Well, first of all, I'd like to also say thank you for having me. I always wonder how it is I end up in some place or in a particular job, and Where's Waldo is one of those things. But I will tell you that we have a saying back home: everything is up to date in Kansas City, and I think we're getting there. The City Council in December of 2021 passed the right to counsel, and there was a group, the KC Tenants Group, which was very vocal, would go to the City Council meetings consistently, and eventually that ordinance was passed. So I worked in a state court, and we had a city ordinance that was going to tell all of us in state court that we needed to advise people of right to counsel in eviction cases. And I did that, and I would see it on the screen. I could tell whether somebody was a Kansas City resident or not. Kansas City is unique. It's 319 square miles. It's in 4 different counties. So the lawyers that would be working, such as for Legal Aid of Western Missouri, they would have to go to 4 different state courts to represent clients in those courts. I was in one of those courts in Platte County, and we have about 115,000 residents there. Kansas City's about 500,000. They funded the program in effectively June of last year, $2.5 million, and it's part of the regular city budget now.
So let me stick with you, and the question that I'm sure comes to all of us is how are these programs working? I mean, the theory is if you don't have a lawyer, you lose, and having a lawyer is going to make a difference. You have really a unique perspective. You saw it from the bench. So how was the program working from that perspective?
Sure. Well, the first thing I would start the docket. I'd have a docket of 80 to 100 cases on a Tuesday morning, followed by trials, usually on the heels of that docket, knowing that I had a criminal docket starting at 1:30. So, and you remember how difficult that can be, and it's stressful. But we would get through it. An attorney from Legal Aid of Western Missouri would make an announcement at the beginning of the docket about the program, and I permitted that. I thought it was appropriate for them to be able to do that. And then somewhere in the middle of the docket, somebody might not realize that they had right to counsel, and I could see it that they did, and so I wanted to make sure that they had the opportunity. Missouri's statutes are very skewed toward landlords. So in Missouri, somebody can take a judgment after service of process has taken place at least 4 days prior to court. And then if the matter is not resolved on the date of court, I have to put it on an accelerated docket, which means 1 or 2 weeks later. So that made it very difficult for people to seek counsel. So I wanted to make sure that they had an opportunity. But it did work well. The folks at Legal Aid provided me with some information. The last year we had, she told me, the executive director indicated that they had 1,330 people that they had represented. 1,157 of those folks were able to stay in their homes, and they were able to, there was either dismissal or a judgment signed, but the matters were resolved. And so it has done very well. And it also would wipe out my trial docket. Because I would say, okay, where are we at with this? And they'd say, Judge, we've gotten it resolved, and it was great.
Well, and that's terrific. And I mean, again, these numbers are sometimes numbing. 3.6 million evictions, 1,100 people or 1,100 cases resolved with tenants in their home. I mean, that's first of all, it's not just one person. It's typically 2 or 5. And it's not just staying in your home, but meaning you can get your job, your child can stay in school, they don't have to change doctors, so it's really a life-saving event. Ron, how have things gone? You know, has it made a difference here in New York City? What's your observation?
It makes a huge difference. People who are represented don't get evicted, by and large. 85 to 95%, I would say, of the time, people do not get evicted. The challenge now is that there are about 170,000 active cases in the New York City housing courts, and only about 30% of those are being assigned lawyers at the moment. So we have a program that we know works, but it's a challenge to build it up to the point where we can actually provide counsel for every single tenant who's entitled to one. So people don't get evicted. They don't have to go to court as often, and so as you say, they don't lose their jobs or lose their pay. When they come to court, they have someone to talk to, someone who can stand up for them, during the process of which they also learn about how they can stand up to their landlord, what their rights are, how they can stand up to their landlords, how they can stand up to their landlord's lawyers. Because one of the things that happens in housing court repeatedly, unfortunately, is that not only are people abused by the whole process, they're abused by landlord attorneys and by their landlords. Sometimes, I'm sorry to say, by judges, not that often, fortunately. But so the whole process is demeaning and dehumanizing, and when there's a lawyer by your side, that doesn't have to happen. So it makes a huge difference. It also, having a larger number of lawyers working on behalf of tenants in the courts allow us to take on and challenge and expose the racist and sexist behavior of landlord attorneys, which occurs all too often, and sometimes court personnel. So there are a lot of positive impacts of a right to counsel program that go beyond the most important impact, which is that people don't lose their homes.
Kabira,
Yeah,
you know, the Office of Tenant Legal Services, so I think you have a good perspective on this as well. What does this look like? How is it working in Newark?
So definitely the fact that we're able to represent more Newark tenants, that, more Newark tenants have attorneys to represent them and provide them with legal assistance when they're facing the threat of eviction has had an impact. Unfortunately, we don't have enough attorneys to represent every tenant that receives assistance from our office, but we turn no tenant away. And frequently, even if we're not able to represent a tenant, we're able to give them, our attorneys are able to give them enough information to represent themselves in court to stave off, their eviction. I also have to say that the existence of our office has a lot of residual benefits, right? Like there's greater collaboration between the judiciary and the tenant advocate community now, since the inception of my office, than prior to. And that's key. Collaboration between the judiciary and the tenant advocacy community is so key to ensuring an effective right to counsel, legislation and office, pro bono legislation, pro bono office, I should say, for tenants facing eviction. That is so key, that level of collaboration. So we're definitely seeing a lot more of that. And we're also creating more of a presence throughout not just the city of Newark, but throughout the state of New Jersey. The tenant advocate community has more of a presence since the introduction of my office in the city of Newark. So it's been pretty beneficial, pretty exciting.
So this is a very tantalizing situation. We have a problem, evictions. The problem is actually precedes evictions. It's a lack of affordable housing, and it's connected ultimately to evictions. We know that if people get a fair shake and they have a lawyer, that they can assert rights and defenses that they have, and absent a lawyer, they lose. We know all that, but sometimes we don't have the funding. Sometimes we don't have the ability to hire enough lawyers, even if we have the funding. Ron, I know you and a couple of other legal aid leaders here in New York wrote an op-ed back in April of this year pointing these things out and really calling for more funding, and you did get another, I believe, $20 million, which, again, $20 million, don't think about it, the $20 million, think about the tens of thousands of people who will probably, as a result of that $20 million, stay in their home. Kabir, let's just stick with you for a moment. How is the funding? How is the availability of lawyers in terms of getting enough lawyers, even if you had the money? And also, are you getting pushback from, landlords or landlord, organizations?
100% to the latter. We get angry landlords calling our office at least monthly. They don't seem to think that it's fair that tenants get free lawyers in landlord-tenant court, and landlords don't get free lawyers. They seem to be ignoring the reality that the majority, at least 90% of landlords represented in landlord-tenant court in New Jersey are represented by counsel, whereas the reverse is the reality for tenants. At least about 90% of tenants facing eviction in landlord-tenant court in New Jersey are not represented by an attorney. So there's a huge power imbalance just starting there. But the challenges are never ending, one of which is recruitment. It's always been a challenge to recruit attorneys who have an interest in this type of law. And it takes a certain type of attorney to do this type of work because it is incredibly challenging. You have to be very passionate about social justice and social justice issues because you will be constantly met with opposition, challenges, and firms that are adversarial firms that are better funded than yours. So that's always a challenge. I would say that for my office, recruitment is probably more challenging than funding. And if we could just get more attorneys who have an interest in this type of work, I think that it would be a tremendous difference. Another challenge that we face regularly is tenants not coming and seeking assistance timely. That's been a challenge since inception. It's a challenge more so now, I would say post-pandemic, and I think that has to do with the speed at which eviction cases in my county, the County of Essex, are going through the judicial calendar. We frequently see tenants that are coming seeking assistance post-judgment, or literally the day before they're being locked out. And I think part of that is service of process phenomena, and issues, which has been an issue in my county pre-pandemic. It continues to be an issue. Many tenants are not being timely served with trial notices, unfortunately. And if you're not being timely served with trial notice, then you're more likely to be defaulted, right? And so oftentimes, we're servicing tenants who, have been defaulted in court. So that's a huge challenge as well. Ensuring that, tenants receive proper notice, timely notice, and also, that they receive notification about our existence. Frequently we hear tenants telling us that they didn't know that we existed until the last minute, until they went to court. And I do have to, applaud the judiciary of the state of New Jersey because they do make a robust effort to inform the community about offices like ours, as well as legal services offices. So that's been great, but frequently tenants don't learn about our existence until they go to court. And so that's a challenge as well, because I think we can all agree that it's better to be proactive, rather than trying to put a Band-Aid on something that is already, when the damage has already been done. So I could keep going, but I know we only have 30 minutes.
Just, you've included a lot of points which are worthy of a quick elaboration. You mentioned the differences in, even within New Jersey, different jurisdictions have different rules and regulations applying to evictions, and this is true across the country. Within states, across states, LSC is currently doing an eviction study that should come out within the next year that's going to talk about that. And there are vast differences. It costs a few dollars to file an eviction in some jurisdictions and hundreds of dollars in other jurisdictions. In some jurisdictions, you can be evicted within a couple days of getting notice. In other jurisdictions, 30 days. Those differences have to have an impact on eviction rates. I don't know to what extent that lawmakers take those differences into account when they're making these laws. The other thing you mentioned is recruiting. And again, across the country, legal aid lawyers are the lowest paid legal professionals as a category, lower even than public defenders and obviously lower than other categories of lawyers. So it's a challenge. Judge Echols, how have things gone? What barriers? And I know your program is still newish, but what have you been seeing in Kansas City in that regard?
One of the things I failed to mention is there's no income restriction with the Kansas City ordinance. So it's open to anybody who's facing eviction, although I assume and I think that by and large it's being used by the people who really need it. And the biggest problem is, just as everyone up here has mentioned, is the lack of counsel. And so that's the biggest hurdle for those for legal aid. There are 3 organizations in Kansas City that provide attorneys, the largest one being Legal Aid of Western Missouri. The University of Missouri, Kansas City fellowship program provides attorneys, I think not very many, but they do provide some. And then one other organization, Heartland, is another organization that provides an attorney or 2. So yeah, that's their biggest hurdle.
Ron, how about, what are you seeing here, both in terms of funding and hiring enough attorneys and any other,
Sure.
barriers?
So in New York City right now, the annual filing rates are approximately 120,000 cases. Of those 120,000 cases, we calculate that roughly 75,000 are eligible to have a lawyer assigned to them. But at the moment, the city's only contracting with the legal aid community to provide 35,000 of those cases. So far less than half the need. And they're paying badly for the services that they're contracting with us to do. So, for example, we have a $30 million contract. Legal Services NYC has a $30 million contract with New York City to provide right-to-counsel services. We're spending $45 million to implement that contract, and we still don't have enough staff to meet the contractual demands. So we are fighting for funding fairness in all of our city contracts. We're also fighting for additional funding to get us all with contracts that would allow us to serve the 75,000 tenants who are eligible for our services. And recruiting and retention are huge challenges. There were huge challenges that started particularly during COVID. We had at one point roughly a 33% attrition rate, which meant for our staff of housing lawyers of 150, we were losing between 30 and 50 lawyers a year. Every time someone leaves, their full caseload has to be handed over to someone who's already on staff, which means that now they can't take a new case. So there's huge logistical problems in building a program the size that is needed to address the need in whatever jurisdiction we're in.
So a number of these right to counsel laws come as a package with other measures such as eviction diversion, mandatory mediation, availability of other services. Judge Eckold, I don't know to what extent that's the case in Kansas City. What do you think would be helpful in dealing with housing issues, beyond or in addition to the right to counsel?
Well, let me just say that cities seem to be the leaders in so many things, when it's right to counsel, whether it's climate action planning, gun control. And so it's a blessing that at least 22 jurisdictions or cities now have right to counsel. It's
Amen.
yeah, and so and it's so incredibly important. I mean, you think about the most prominent case on my landlord-tenant docket was a single-parent family, and you can imagine the eviction process and what impact it has on the children and their futures. And so just gathering data, the data that they already have gathered thus far is good. Hopefully the funding will improve. It's budgeted for next year, and so things are looking up.
Kabira, what's your final observations in this?
So I have a lot of observations, and again, I know that we're only limited to 30 minutes. I do know that one of the topics that we were asked to discuss was some recommendations for folks who are interested in right to counsel legislation themselves. And one of the things that I would encourage you to do is look at your state constitution and look at your case law, because New Jersey has a consequence of magnitude doctrine that our Supreme Court introduced in the 70s, I believe it was in 1971, and it provides that if an indigent defendant in any type of case is facing a consequence of magnitude in that case, then a right to counsel is invoked. And it is because of that doctrine that we now have a right to counsel in adoption cases, right, in the state of New Jersey. And I think that will form the basis of right to counsel, in eviction cases in the state of New Jersey as well. And a lot of our right to counsel advocates in New Jersey are actually pushing, using that doctrine to push for right to counsel in eviction cases, because losing one's home is absolutely a consequence of magnitude. So another recommendation that I would have for pro bono attorneys in general is to take your time. Most of us are incredibly compassionate people, right? Like, I think most of us, at least those of us who've been doing this for a long time, are not in it for the money, but we're doing this type of work because we're passionate about the issues. It's not a job for us, it's social justice work. And with that comes the discipline to not react and want to help every indigent tenant that is coming to you with a lockout scheduled for tomorrow, right? Like, ethically, you can't do that for every tenant that comes to your office. And I find that that's a challenge for myself every single day. I've been practicing law for almost 20 years. And that's still a challenge for me every day. But you have to set a boundary and tell yourself that investigation is an ethical requirement, right? Like, you can't represent someone or develop a theory of the case unless you're able to thoroughly investigate. I mean, the same principle holds for a medical doctor, right? You have to diagnose the patient. And so, I find that that's a principle that I really have to follow in the political, government context, because you have a lot of folks who I'm going to try to measure my words. A lot of folks expect you to give on-the-spot assistance, right? And literally, like, I guess, they, on the TV shows, you drop what you're doing, you show up in court at the drop of a hat, right? And so you have to exercise that discipline and, set boundaries for those around you as well, because they will expect you to drop what you're doing for example, the 82-year-old constituent tenant residing in subsidized housing who's going to be locked out pursuant to a warrant of removal tomorrow. But you've got maybe like 5 other open cases with similarly situated tenants, so you kind of have to be disciplined and triage yourself and, and set boundaries. And it's not heartless to say that, unfortunately, I will not be able to go to court with that 82-year-old constituent because I have an open case, and I'm responsible for that case first. So, those are just some of the recommendations that I have, and I will.
Thanks so much. And, I think your first observation about the state constitution dovetails perfectly with the remarks of Chief Judge Wilson about constitutional interpretation. These really are fundamental, if not rights, fundamental human concerns. Ron, you get the final word.
So, final word, wow. Well, work really closely with tenant organizers and tenant associations and community-based organizations if you're going to build anything that is going to improve tenants' lives. Work really closely with the judiciary and city government if you're going to build a program that is going to last. Figure out how to balance the urgency of the need with the need to build a foundation for a program that can withstand the test of time. You can't hire 50 lawyers tomorrow unless you've already got 5 to 8 supervisors who are there waiting for 50 new lawyers who they can supervise, and that's hardly ever the case. And finally, although all this talk is about the importance of a right to counsel, don't let right to counsel funding suck the funding away from the other really critical housing work that needs to be done to address discrimination in our communities, to address landlords who are systematically illegally registering rents in the communities. There's a lot of systemic and system change-oriented work that needs to be done, that has to be done if we're going to build communities that are stable and that are integrated and where we're attacking discrimination. And if all of the funding is going to one after another after another after another of eviction defense cases, then we're gonna lose the battle over time. So right to counsel is critical, but don't let it suck all the money from all the other good stuff that has to be done.
With that, please join me in thanking our panel. Well, we've just been talking about right to counsel, the importance of lawmakers, the importance of leadership, and that all brings us to our next speaker, a lawmaker and a leader. I have the honor of introducing New York City Council member Gale Brewer. Councilmember Brewer represents the 6th Council District, encompassing most of the Upper West Side up to 108th Street west of Broadway, a part of Clinton, and all of Central Park. She was Manhattan Borough President from 2014 to 2021, and during her tenure, she convened important task forces, including, pertinent to what we were just talking about, one on affordable housing. Councilmember Brewer completed her undergraduate degree at Columbia University and Bennington College and has a MPA from Harvard's Kennedy School of Government. Thank you so much for joining us today.
Thank you very much. It's a huge honor to be here, and I have to say this is a topic that is of utmost importance to the whole city. I thought you might be interested. I just came from Tacoma, Washington a few days ago, meeting of the National League of Cities. These are the smaller, not the large ones. LA sends maybe one person, Chicago, but sometimes it's 3,000 people, 30, a million. There were 300 people there for the summer meeting. I was surprised, maybe you won't be. Literally every single town said our number one issue is the lack of affordable housing. It didn't matter what size town, and it didn't matter also that the other issue, which I get, is not in my backyard. So even though the mayor or the council might want to build the affordable housing, I guess something similar that the governor of New York faced recently when she was trying to build housing in some of our suburban locations. But, I mean, it was just universal from across the country. So we're not unique, and certainly, obviously, having wonderful legal aid attorneys to help us to provide this housing and to make sure discrimination does not take place, which it does, was also part of the conversation. So I just thought you should know that that's what is everywhere. In terms of the city and my district, so on the budget negotiation team, we have new council members, Shekhar Krishna, who's a wonderful Queens legal aid former attorney, and of course, Sean Abreu, who's from Manhattan, former legal aid attorney. And they worked really hard, we all backed them up, to get as much money as possible for legal aid. They were like a dog with a bone on this topic, and it helps. That's why you have a new council, why it's more diverse, and why people come from different backgrounds to the city council. So I think it was somewhat helpful. Those who are here know better than I, but we really did try to do the maximum. You heard the numbers and the statistics. Just one example, I work a lot with the Immigration Coalition, one organization. They have 145,000 cases that they can't cover just because of the lack of support in terms of their funding. That's not just legal aid and support, that's just general, the migrants and everybody else. In terms of specifics that I know of, even when I was in the council before, I was there under Bloomberg, well, not under Bloomberg, we'd fight with Bloomberg, but I was there in the early 2000s, as some of you know, and certainly Peggy knows, everybody knows. The issue of affordability was still relevant, even as much as now, perhaps. And so we always had a housing clinic once a month with Take Root Justice and Goddard Riverside. And they are great because you can come, no matter who you are, in person, then virtual. Now we're going back to in person. And no matter how much, I mean, we get tons and tons of people with a general question and then an individual question. And lawyers there from those two organizations to help, and sometimes, thanks to many of your law firms, pro bono attorneys also. No matter how many times we try to get more money, more assistance, there's just too many people asking questions and too many people with close to eviction situations, holdovers, et cetera. So it's quite, it's really, really challenging. I have to say, in my district and across the city, I've been to every HERC, I think, run by Health and Hospitals, and we've certainly been to all of the family shelters over time, and the stress of both pro bono legal aid from the law firms, which I believe many of them working out of the Red Cross building on 49th Street, plus the individuals who are working like you are, legal aid, working with this immigrant group is challenging. I go to the shelters a lot, and my Spanish is limited, but I can understand. And all they do is talk about how they're going to get their papers filed. It's the only topic, because it's the only way they have some hope of getting asylum. I think only 30%, as I understand it, of the whatever we have, 81,000 people here anyway, who have come through the city. Maybe 54,000 are in shelter right now. That is the number one topic. So that also stretches all of legal aid in today's world. I don't think anybody would have predicted that kind of challenge. And you know better than I how you get working papers, or don't, depending on how you file your papers and when you get your asylum hearing, if you do, and if the president would ever sign temporary protective status, that would be very nice. All of those issues are on my list. So I think what you're talking about today, and there's certainly many more experts in the room than I am, We need more money for the budget on this topic. I think there was some from the state, but not enough from the city, not enough from the state. And also retention. Of course, on the city level, you have the same problem. You have very few, for the while, the mayor would not give any kind of virtual employment. And I don't think any attorney would join the city because you have opportunities to have some virtual elsewhere. Hopefully that's changing. I think we finally got it into his head that he has to do some virtual. I'm trying anyway. And then, so the same problem. You know, I heard earlier, hard to retain, low salary. Same thing for the city, hard to retain, low salary. I was at a meeting this morning with Pfizer, this will make you feel better, fancy building, I mean, everything new. Guess what? Hard to retain. And the way they do it is they have coffee and donuts in the morning for everybody. I was wondering why the line, because I thought it was so long to get in. I thought, oh God, I have to wait in line. I'm already late for this meeting to get my coffee. So we were in a different conference room. But this line was all the way down the hall to get donuts and coffee so they could show up. That's what Pfizer said, not me. And then JP Morgan said, oh, we have no problem, they all show up. Anyway, I'm just here to say congratulations, thank you. Let us know in the City Council and any other government entity what else we could be doing. It's always challenging, but your input is more important than anybody else's, and you're doing God's work. Thank you very much.
Thank you so much, Council Member Brewer, and keep it up. We need voices like yours and many more of them. It's now my privilege to introduce my long-standing colleague and friend, Mike Schmittberger. He is the chair of our firm's executive committee, an accomplished graduate of Columbia College and Columbia Law School, where he was the editor-in-chief of the Columbia Human Rights Law Review. Mike is the co-chair of the board of directors of the United Way of New York City and is a representative to the Partnership for New York City, the nonprofit membership organization consisting of New York's business leaders. Mike previously served as global co-leader of the Investment Funds Group and managing partner of Sidley's New York office. Close to my heart, though, Mike has been a true champion of our work here at LSC, and I am so grateful to him for taking the time out of what I know personally is his tremendously busy schedule to be with us here today. Mike Schmittberger.
Thank you, John, and also for your long relationship and for your service to LSC. And being here, the honor is really all mine. Today, with some apologies, I offer you a mashup of my two favorite quotes. The first is Niels Bohr, a Nobel Prize-winning physicist, and the second part you will all recognize as Dr. Martin Luther King Jr. Quote, although predictions are difficult, particularly those involving the future, the arc of the moral universe may be long, but it bends towards justice. Close quote. And I combined my favorite quotes for this audience because, of course, the arc of the moral universe does not bend of its own accord. It takes the efforts of individuals and organizations like LSC and the others represented here to bend that arc or to prevent others from bending it backwards. Also true, some outcomes are, in fact, predictable. We can predict better outcomes for the underserved and marginalized when we devote our time and treasure to providing access to civil justice and, more broadly, to social justice. Our time and treasure are leveraged. That is, the arc is bent better by LSC, which does direct work, like the report of LSC opioid task force. But LSC also acts as a funder and a convener among a great number of civil legal assistance not-for-profits and the private sector. And bending the arc better should matter to the private sector, and especially to those of us in big law, because when greater numbers of the less fortunate among us have access to civil justice, when they are housed, when they are not hungry, and when their children are able to learn the basics, we and those with whom we work do better. We all benefit. Our cities do better. Our nation does better. We at Sidley Austin are proud of our long relationship with LSC. So my thanks to LSC, to the Ford Foundation, and to each and every one of you for helping to bend the arc better. It's now my privilege and honor to introduce our next speaker, ABA President Deborah Enox Ross. In addition to her service at the ABA, Deborah is a senior advisor to the International Dispute Resolution Group of Debevoise and Plimpton. Previously, she served as senior legal officer with the World Intellectual Property Organization's Arbitration and Mediation Center in Geneva, Switzerland. She served as chair of the ABA's Policymaking House of Delegates and as chair of the ABA Center for Human Rights. As chair of the ABA International Law Section, she co-founded the Women's Interest Network and worked with the International Bar Association to create its Women's Interest Network. Notably, Deborah started her career as a legal aid lawyer. Thank you for joining us today, Deborah, and thank you.
Good afternoon. Oh, okay. So it is on, right? Okay. First, thank you for that very kind introduction. And it is really an honor for me to stand here as president of the ABA. This will be my last official remarks as ABA president before going next week to Denver and turning over the gavel to the next ABA president. So it is particularly special for me to be able to do that in my hometown before an organization where, as you heard, I got my start as a legal services lawyer. And it really is a privilege to have been, I keep talking in the past tense, and they say, stop talking in the past tense, because I'm still ABA president. But to stand before you and to talk to you about what I think is an important partnership between the ABA and Legal Services Corporation. Access to justice is a fundamental focus of the American Bar Association. And a major element of our commitment is our long-standing partnership with Legal Services Corporation. In 1974, the ABA was a prominent and integral supporter when Congress created the Legal Services Corporation. And ever since, legal aid funding has been, for us, a nonpartisan, unifying issue of critical importance to the ABA and to the legal profession's core value of equal justice under law. The ABA's access to justice advocacy is informed by our Standing Committee on Legal Aid and Indigent Defense, known by its acronym SCLAID, or SCLAID. SCLAID collects and analyzes legal aid funding data in its legal aid funding report, and its findings underscore the dire need for funding. We use data found in the Supporting Justice report issued by the ABA Standing Committee on Pro Bono and Public Service, as well as data from the National Bureau of Labor Statistics, to determine the average cost for representation in a typical civil legal aid matter, and then compared it to the overall funding available for legal aid. And I don't need to tell this audience that the results are dire and eye-opening. And that is why, for us, it is clear from this data and from all other sources that our nation is not even remotely close to adequately in funding civil legal services for those in need. And that's why this year on ABA Day, I was in Washington with an army of 165 lawyers from 35 states, where our priority at this annual event is to underscore from members of Congress the need for robust funding of the Legal Services Corporation. Our advocacy year after year delivers our message loud and clear that legal aid helps keep our justice system functioning. We emphasize that the federal government has an important responsibility to meet our constitutional promise to establish justice. And we note that legal aid supports constituent services back home for veterans, for seniors, for rural Americans, for Americans living in large cities and small cities, for domestic violence survivors, for children, disaster victims, and more. And this is especially important to me because, as you heard, I began my career here in New York City at MFY Legal Services. And I actually began my career in landlord-tenant court. So as you were talking about the challenges that tenants face, it really reminded me of my experience. And it also reminded me that it was some of, at the same time, most rewarding work that I've ever done, but the hardest work that I've ever done. And to be able to keep someone in their home and all that flows from that is a singular honor and a singular privilege. And so I have never forgotten how important that has been to me in shaping my legal career. And I actually thank those that I serve with because they really taught me how to be a lawyer. I tell people all the time, if you want to know what it's like being a litigator, there's nothing like landlord-tenant law in New York. You get thrown into the deep end and you got to figure it all out. And those skills I have been able to take with me everywhere I've gone. And you were kind enough not to read all the places that I've worked because sometimes it feels like, can't she hold a job? But it's not that, it's that I like to just be interested in different things. But nothing was more foundational than my work in legal services. And so I want you to know that everyone should know that you have a strong and steadfast ally in the ABA. The ABA is proud to collaborate with equal justice advocates and providers, including Legal Services Corporation, corporate and law firm pro bono initiatives, leaders of the judiciary, lawmakers, state and local bar associations, and more. We use the convening power of the ABA to bring all of the stakeholders together to advance the cause of equal justice. So for me, thank you for your outstanding work and advocacy to ensure that equal justice we do live equal justice under the law. And I have made it a point to visit legal services offices wherever I've gone, and I feel like that song, I've been everywhere, man. But ironically, I don't think I've visited legal services right here in New York, so I may have to do that between now and next week so that I can say I got that in. But everywhere I go, I tell them, when I meet with legal services lawyers, thank you, because I know the work is challenging and you don't get paid enough. And that it helps to know that the ABA and the lawyers in the ABA are supportive. And then the other thing that I've done is talk to law students, and I try to go wherever I go, talk to law students, and in particular, there are 6 HBCUs, historically black colleges, that have law schools. And I've made it a point to speak to those law students in particular and talk to them about the incredible opportunity of being a legal aid, legal services lawyer, and some of the challenges, and thinking about ways that we can have internships and make it easier for them to be able to do the work that they love to do. You are right, as you said today, people who do this work, it is a calling, and it is because they really believe in the mission. They don't do it to make a lot of money. They should make a decent living. That's different. And so it's up to us to try and make sure that we can close that gap. So on behalf of the ABA, thank you for all that you do. You are an incredible example of what it means to be in the legal profession and to stand up. And it is my privilege and honor to be able to say that to you. I respect all that you do to defend liberty, pursue justice, and make a positive difference in people's lives. Thank you very much.
Thank you, Deborah, for your remarks and for your service of all these years. My name is Lori Mikva. I'm a member of LSC's Board of Directors. It's my pleasure to introduce our next speaker, Professor Douglas Eakley. He's the, this is a mouthful, Alan B. Lowenstein Professor of Corporate and Business Law at Rutgers Law School, a distinguished professor of professional practice, and the founder and co-director of the Rutgers Center for Corporate Law and Governance. Professor Eakley joined Rutgers in 2012 after several decades in private practice, where he specialized in complex commercial litigation. He's an inductee into the New Jersey Equal Justice Library and the Archives Circle of Justice. He's received numerous awards, really like a whole page, for his pro bono work and valuable contributions to the community. He's also, as you know, served as a former board chair of LSC, showing the way to John and Frank. Please join me in welcoming Professor Eakley.
Thank you, Lori. I feel somewhat old standing up here before you, in part because it was 30 years ago that Lori's father, Judge Abner Mikva, swore in the Clinton LSC board. I actually had my first experience with legal services in 1970 when I joined the Yale New Haven Legal Services Clinic as a student. That was 8 years after the Ford Foundation launched its Gray Areas Initiative, which ultimately incorporated a neighborhood law office component, which was designed largely by the architects Gene and Edgar Kahn. That program was the precursor of the Organization of Economic Opportunity Legal Services Program, which in turn became the model for the Legal Services Corporation Act that was enacted in 1974 and signed by President Nixon. So it's so fitting that we're having this sort of program here in the Ford Foundation on the very first day of the 50th year of the creation of the Legal Services Corporation. I want to go back to something else that John said, and I want to reiterate it. Actually, I want to quote it because it's foundational. To establish justice is the very first goal in the United States Constitution in terms of how to recreate a more perfect union. It's really hard to conceive of a democracy that doesn't devote itself to justice. You can't have liberty and you can't have justice unless you have access to that justice. And indeed, unless access is at least approximates equal access, it's not really a justice system at all. This is not merely aspirational. Our democracy and rule of law is fundamentally dependent upon the premise that courts will be fair for everyone, that poor and rich alike will be treated equally. And yet, as we all so painfully know, in most cases, access to our courts and to justice is dependent upon having access to a lawyer. Perhaps surprisingly for some, and in fact, as many of you have, as I have over the decades, gone to the private sector for financial support, we frequently met with surprise. I thought this was the government's responsibility, but it's not. It is or should be certainly a principal responsibility of government. But as Chief Judge Wilson pointed out so effectively, there is no constitutional right to guarantee to legal representation in civil legal matters, although there should be as a function of the common law that we inherited. Even though the lack of a lawyer can often mean a wrongful eviction, the loss of a child, the theft of benefits, unfair treatment by the unscrupulous, and much more, all frequently without due process of law because of that lack of access. The federal government came tardily and cautiously to providing some modicum of federal funding to our current legal services program. 1974 is our watershed year. Since then, LSC has survived some turbulent times, a 25% reduction in federal appropriation at the beginning of the Reagan administration, reflecting the then Governor Reagan's experiences, litigation with and against California rural legal assistance being one of the principal causes. Fast forward to my third year as board chair of the Legal Services Corporation. Congress in 1995 with, I'm not on the board now, so I can say, Congress, some will say that Congress came in that year with a contract on America, and the Legal Services Corporation was part of that contract. Budget resolution, eliminate federal funding altogether over 3 years, 1/3 per year. So we had a 33% reduction in a single year of appropriation for LSC, coupled with an elimination of federal funding for the delivery system of legal services, namely national state support services, including my own legal services of New Jersey, elimination of federal funding for legal services clinics, and a host of restrictions imposed with those federal funds on the recipients, restricted not only for how they might use federal funds, but also how they might use funds they raised from state governments or other sources. And those restrictions included prohibition from engaging in law reform, class action litigation, legislative advocacy, among others. In other words, an attempt to reduce the ability of legal services lawyers to undertake impact litigation or advocacy on behalf of their clients. Fortunately, the damage that was done in that year found recoveries in a variety of different ways, and very few of our national and state support centers went out of business. They actually became strengthened by, excuse me, I'm sorry, state governments stepping up to the plate, private funding, and a lot of pro bono advocacy. Since 1995, the good news is that the Legal Services Corporation has received bipartisan support in the Congress almost uniformly, with regular increases in LSC's appropriation. But the Congress has never appropriated anything like the order of funding that would be required to close the monstrous justice gap between the legal needs of low-income individuals and families and their ability to access lawyers and justice. Indeed, since 1996, LSC's annual appropriation has increased at a rate only 1/5 the rate of the increase in the overall federal budget. As a result, the unmet needs of low-income individuals and families remain vast. We are rationing justice on a daily basis in America. I believe it is a fundamental government responsibility to assure liberty and justice for all, but the responsibility for assuring access to justice does not and should not rest solely with the federal government. Lawyers in particular should serve as gatekeepers of the legal system. We are in many ways the principal beneficiaries of the legal system, and we should be its stewards. More broadly, everyone can and should play a role in assuring access to justice. Which brings me to our next panel. In May, more than 200 general counsel and chief legal officers, many of whom represent the largest corporations in America, co-wrote a letter urging the Congress to strengthen its investment in equal justice by increasing funding for the Legal Services Corporation. In their letter, the business leaders drew attention to the current crisis in civil justice for all American families, as well as LSC's unique ability to respond to this crisis. Today, LSC has invited 3 corporate leaders from the New York City metropolitan area to add their perspectives on closing the justice gap and the call to action shared by their private sector peers. I'd like to welcome LSC board member Robert Gray to the stage, who will moderate the discussion. Robert.
The best thing about going last is you get to set the rule for going last. We've got we've got to do a hard stop very shortly. So if you will give me a little bit of room, I'm going to let our colleagues here do more talking than me asking questions. Let me start by introducing Michael Bosworth to my far left. Michael's a partner and deputy general counsel in the legal division of Goldman Sachs. To his right is Deneen Donnelly, is senior vice president and general counsel of Consolidated Edison of New York. And Matthew Darnauer is the chief legal officer of Heineken USA. They both have all 3 of them have very distinguished careers leading to this moment, and I urge you to Google their names and find out more about them. But today, what we're going to do is we're going to ask them about the important ecosystem that exists in our society, the relationship between our corporations and those that work at those corporations in support of better and stronger communities within which we all live. It is not uncommon for us to be in the same room together supporting legal services. This is a tradition, as Doug has talked about, as Frank has been a part of, as the 2 presidents of the ABA know very well, is the way we are designed through our legal training to support our communities, the organizations we're a part of, in a better United States of America, in the quest for a more perfect union. Let me start, Matt, with you, okay? You were one of the signatories to the 208 that signed the letter asking for better funding and more funding for legal services. Tell us how you have used your position to set up and build a culture within Heineken in support of our citizens who need our assistance moving forward.
Yeah, absolutely. First off, I want to give a plug to the letter and signing it, and I know that I've tried to recruit, and I will continue to recruit other signatories because I think we had a record this year, 208, but I'd love to see us break that record next year, and there's no reason why we shouldn't. In terms of what I'm doing to build a foundation at Heineken, I'm still relatively new to the role. I've only been here for about a year and a half, and when I got here, I realized very quickly that there wasn't a formal sort of pro bono program or anything of that nature. People were sort of doing, this or that, but there wasn't anything, that was kind of foundational. So I think that's what I've tried to do. And, I think the first step in doing that and setting up a pro bono program in-house, this is the first time I'm doing that, by the way, is one, to get buy-in from the top, right? You need to get buy-in from the leaders of the company, in particular the CEO, of course, me as the head of the legal department, but you need to start there. Secondly, you of course then need buy-in from your legal team. They need to be on board with what you're doing. And what that means for us is getting alignment on exactly what type of law, what type of public interest work do we want to be involved in? And then, where are we going to do that at, of course? And, most of our folks are from the Metro New York area. So, we're actually in the process of doing this, figuring out with whom we're going to work. So, that is sort of step two, is the alignment piece and the accessibility, for us to see the work in our community. And then lastly, I think the last final piece of the puzzle is the training. And oftentimes, you folks in here offer up tremendous trainings, but there's other avenues for that too. There's mentors, there's others. Hopefully, maybe I could. I have some pro bono experience, a decent amount. I could help with some of the projects that we might take on in our department. So those are kind of the three pillars to help establish a pro bono department.
Matt, thank you.
Sure.
Michael, let me go to you, Goldman Sachs has been in support of communities for a long time. In 2022, 18,000 volunteers provided services to over 500 partners that you have that serve our community, nonprofit partners. As you think about the work that we do to connect the dots, to make and strengthen the fabric of American society, talk to us about your advice that you would give to others similarly situated in the corporate community, particularly as they think about what their role is as pro bono lawyers or in support of other community partners. How do you do that when part of what you do that's not necessarily in your wheelhouse when you come to work that day? What is the way you encourage others to think about their role in our society and in support of access to justice as we think about building out a more robust safety net to help all of our citizens gain access to the courts? You got it. Voice activated.
So I feel like that was a very nice way of asking, why should somebody who spends a daytime providing legal services to high-income people have anything to say that we care about for providing services to low-income people?
I'm glad you deciphered that.
And I guess I'd say, first and foremost on the lawyer part and then on the institutional part. On the lawyer part, I think everybody in this room recognizes that there is a crisis in access to justice. And what is particularly infuriating, I think, about it is that there are so many people in need and so many lawyers who want to help, including lawyers who work in-house or at law firms. And part of the goal of in-house lawyers, I think, has to be figuring out the right opportunities and the right way to motivate people in-house to spend time helping people who need it. For me, that's not just something you absorb in the world. It's something that I've learned sort of every step of the way in my career. I spent a long time in public service, and I think the access to justice issue is one that I came to learn a whole lot about at the end of the Obama administration. I was Deputy White House Counsel and got regular calls from John Levy pressing for money for LSC, and he was as smart and as tenacious and as passionate as I think all of us need to be about that cause. I don't know how the Obamas did on that front. I think pretty decently. I think there's obviously a long way to go. But it's something that we have to do as lawyers. And I think, that's why we spend a tremendous amount of time at Goldman encouraging lawyers to work with our pro bono partners on immigration rights, housing rights, re-enfranchising, formerly incarcerated. There's a whole range of projects where lawyers can pitch in. I also think there's a special responsibility of institutions, particularly institutions that have the financial wherewithal to change the communities around them, to actually take a stake in changing the communities around them. I know Goldman, like the other entities, who have lawyers up here, has spent a lot of time and a lot of effort and a lot of resources trying to build a better community around us, which they have done in investing in small businesses, in access to funding for people of color, spending billions and billions of dollars trying to level a playing field that all too often feels very unlevel.
Speaking of sharing, Deneen, I'd like to ask you, as really a new general counsel, each one of you have transitioned from another position. I just happen to have a good take on Deneen because she is on the board that I serve. And so before Con Ed, you were at USAA as general counsel, but inheriting the general counsel's office at Con Ed, you've got an organization that's given $12 million in grants.
And actually, we upped that this year to 15.
Well, that's because you're there.
It is not me.
Which is where the question was going to go. What are you going to do now that you've got the keys to the kingdom? But the other thing is, and we this is something that we just intuitively understand. When a crisis hits this country, we call on our corporate leaders and citizens to step up. There are no more important things to consider in terms of people's health and their access than what happens when there is a pandemic, there is a heat wave, there are broken pipes, and Con Ed serves 10 million New Yorkers of every stripe and variety and income level. How do you balance the need to support all of the citizens that have access and need you with those that require your attention to performing at a high level and a profitable level at the same time?
I would say that making sure that we are advocating to support people who would have trouble paying their utility bills. So, for example, there is a program that aims to have low to moderate income individuals pay no more than 6% of their income for their utility bills. And everything that we do has to be approved by our regulator. So we spend a lot of time, my team, the regulatory attorneys are making filings so that we can effectively support people who in fact can't pay their bills. Yes, we're obviously an investor-owned company. We want to make a reasonable rate of return, but we also recognize that we're part of the fabric of New York City, and it is our role to make sure that the lights stay on and that individuals do not lose their power. So finding ways to work with people so that they have access to utilities that are just essential, as we learned in COVID. You need to have so much more than the lights now. We just spend a lot of time doing that, and my team is fortunate to support that. And I would say, me personally, I am more of a thought leader. So my job is to partner with corporate affairs, with our CEO, and to really talk about what we can do to support our communities, and to make sure, to be honest, that there's a voice in the room who doesn't just take things for granted as far as affordability. It is very easy to say the average bill is X, and therefore the burden, of course, is affordable. But I like to remind people that there are a lot of things that people have to pay for these days. We have many customers who are still experiencing hardship, and that we need to be thoughtful as we are advocating and as we are making statements about affordability, that even though it may seem that it's affordable, first of all, there are people who don't fit into kind of the low-income programs that we have in place, sitting right on top of that, for whom the bill is not affordable, and what can we do to help support people? And we spend time on that.
It is, I have some more questions, but here's what I'm going to do. I'm going to reach a compromise with you. And I'd like to give you each 2 minutes, as opposed to 3. And what I'd like for you to do is share your this is the we're going into the 50th anniversary. It is our turn to make a statement about what this means to us in the legal profession and what it means to American society. I'd like for you to share your thoughts, your closing thoughts, as we move into this very important time of education and renewal. And tell us what you believe we ought to be thinking about, what it is corporate America needs to do, and how do we connect the dots to make this a more perfect union. Matt, you're up.
No pressure. Yeah, I mean, phenomenal question. And you know, I'm truly humbled hearing, you know, everything we've heard today. And obviously there's an immense, tremendous need for corporate America to support the great, great work that everybody in this room is doing. And I think it starts with us leaders of these companies, and being vocal with our CEOs, our boards, and really making sure that we provide the funding, we provide the lawyers when we can provide them through pro bono work. You know, that is integral. We need to be partners with you. That is, you know, bar none, what needs to happen. And I would love to see more of corporate America, you know, hence my plug for more folks, more GCs signing that letter. There's a lot more than 208 of them in this country that support the work that LSC does, and they should be, you know, frankly, putting their money where their mouth is. And you know, I'd love to see that. I'd love to see more, you know, of corporate America really taking a more proactive role in supporting what everybody in this room does.
Thank you. Denise?
So this is similar for me to CRA. So I was in financial services for many years. So the idea that every company is going to give back, there's so much that we can do to support people who need access to justice, to support the rule of law. We are not telling people what to do, how to vote, but we certainly want to make sure that people are able to, and that we have the resources, I'd say dollars, as you mentioned, but volunteer efforts. I think about the pro bono work that we do, and I have my pro bono team here. I just want to call that out. You know, we make sure that it's not just lawyers who can engage in it. We have different things that paraprofessionals can do, and the whole company can be putting their volunteer efforts to support social justice issues in addition to money, in addition to advocacy. So I just think there's a lot of work to be done, and we should not be afraid to step forward and to be vocal and be supporters.
I should also note that you spent time, not only as a financial analyst, but financial budget person with New York City and the Federal Reserve of New York. So, you know, you've got a little bit of
we had someone that said she's had a number of jobs. I've had a number of jobs.
And Michael, not to shortchange you on your activities, but you know, having been a special counsel to Federal Bureau of Investigation and co-chief of Complex Frauds Unit of U.S. Attorney's Office, Southern District of New York, is no short shrift of activities and of legacy and contribution. How do you see us moving forward? And you've got the last word.
I guess taking a step back, we pride ourselves on being a nation of law, and corporations benefit from that, individuals benefit from that. But it only works when the law is accessible to everyone, when everyone gets the same benefit, the same protection from that law. And if you tell a significant portion of the population that the courtroom door is closed to them because they can't afford it, we won't be a nation of law in the way that we would want to be. And all of us, right? I think, today we got to sit through just a tremendous program of thinkers and activists and corporate lawyers and public servants. My council member, hello. That's what it takes to address this problem. And it requires all of us, I think, no matter where we come from, to acknowledge the problem that we face and tackle it head on. And my husband works at Callan Lord, which is a network of community health centers here in the city, and it's focused on mostly LGBT, mostly underprivileged people. And Audre Lorde, who's one of the namesakes of the center, had a quote that I think is a good place to end because it captures, I think, what an approach should be on this issue, which is, when you're facing difficult times, do something. If it works, do it more. If it doesn't work, do something else, but keep going. And I think that that's what we have to do in the face of a problem that is one that we all have to tackle together.
Well said. Join me in thanking our panel.
Just in parting, want to thank all of our panelists, all of our speakers, and all of you for making this first day of our 50th year such a smashing success. And I want to invite all of you to join us at the Paul Weiss Firm at 51st and 6th Avenue for a celebration of our pro bono heroes for the legal aid programs in the greater New York metropolitan area. Again, thank you for being with us.